Welcome to the Security Operative podcast. This is Tony O'Brien of Security Operative Consultancy Services, here to share with you my perspectives from the world of security and risk management. Enjoy the episode. Morning and welcome to episode number 35 of the Security Operative podcast. Tony O'Brien here from Security Operative Consultancy Services. Back again for 35th episode of the show. And in this episode, it'll be probably more specific to the Irish audience, I suppose. I'm going to talk about a brand new piece of legislation that's been put before the government this week and approved, hasn't been signed into legislation yet, the Private Security Services Bill 2021, which essentially was purported to license enforcement guards in Ireland and bring them under the remit of security licensing. So I'm going to talk a little bit about that, why, and then some other stuff that's been put into that legislation but I don't necessarily agree with, what's in the legislation and what's changed, what they've used to amend the principal legislation. So a little bit of background on it, I suppose. In Ireland, over the last number of years, we've had some, I suppose, pretty high profile and poorly publicly perceived incidents of evictions from homes and businesses where private security companies would have been used. Up to this point, and including now, evictions or people supporting evictions or enforcing court orders weren't subject to private security authority licensing. There was a pretty infamous one in Roscommon in Ireland a couple of years back where there was a prosecution taken, and we'll talk a little bit about that later on. I won't go too much into the details of it, but essentially the state, due to the negative public perception of these things, have decided to bring about regulation of this particular industry. So this piece of legislation was required to bring enforcement officers, or what they term enforcement officers, under the umbrella of the security industry. Now, you can argue the morals of that. There are already some security companies who are in that particular area and they do that. You know, I would argue about whether they are actually security companies or not, or whether that is a complete different sector. I personally don't believe it should be part of the sector. Reason for that being, I don't believe it is security. I believe it should be regulated. I just believe it should be regulated by somebody who's not the security regulator. It's a challenging area for the security regulator to manage, in that they don't really have any knowledge or experience in the area, and they're going to be facing an awful lot of public pressure from this for a very tiny sector of the industry. So I want to talk a little bit about the bill, I suppose. And for those of you watching online, I suppose I'll see if I can share the bill up online. Yeah. So it is the Private Security Services Bill. Or it's a draft still. It's been approved by the government this week, so it still has to be signed into law, I suppose. Private Security Services Amendment Bill 2021. So it essentially amends sections of the Private Security Services Act of 2004. And like I said, yeah, I personally don't think that security companies should be adding this on as a sector, and I'll tell you why in a second. They brought it in, and I think it was absolutely necessary to bring in a bill to regulate people acting in this area, because there was no regulation of it. And you can say that the companies were heavy-handed or out of order, but the reality is there was no guidelines that they had there to follow, so they were making it up as they went along anyway. And absolutely, there was some people doing it that shouldn't be doing it, and there were some cases that shouldn't have been used, where the use of force, I would find it very hard to justify. And so I think it was absolutely necessary. But what I'm mostly concerned about is the other pieces of amendments that they sneaked in right at the very bottom. If I could talk a little bit about how they announced it. So the government announced it on their website very publicly. Said, okay, they put it in all the newspapers and stuff like that. And they said, well, we're bringing this in because we need to license enforcement guards. And it's put out very positive. It is a very positive message. And then at the bottom of that was one particular line. It will also make other amendments that will allow the private security authority to prosecute everything. And this is where I have a major issue with it. And I think the security industry should have a major issue with it. And I'm amazed that the security companies are not up in arms about these particular sections of it, okay? Essentially, I think the regulator is stepping far beyond their remit. I don't know if they got legal advice on it, but I could see a legal challenge to this, absolutely scrapping sections of this legislation. Because it's crazy, some of the stuff that's been brought in. And I won't say it was brought in by stealth, but they absolutely didn't publicise these pieces of amendments as much as they did the enforcement end of it, which I think needed to be brought in. So let's talk a little bit about the amendments that I was talking about. And if you're watching me on YouTube, you'll be able to see it on the screen. If you're listening on a podcast, I'll attach it to it. So essentially what I'm talking about is Section 4 of this bill. And that amends Section 26 of the Private Security Services Act. And that's the part that deals about suspending or revoking a license. So they've added in here that they can refuse to renew a license, absolutely fine, or at any time suspend or revoke it if they are satisfied on reasonable grounds. And then they give another one, which I think is absolutely fine. They say, look, if you've given false information, that's absolutely fine. If you've contravened any provisions of the Act, that is absolutely fine as well. It's the next two that I have an issue with. It says that this matters whether or not the licensee has been convicted of an offence in relation to the contravention. So you could have a complaint made against you. The police come and investigate that complaint, and they decide that A, it doesn't warrant going to court, or the DPP decides it doesn't warrant going to court, or B, you go to court and the judge finds you not guilty, or the case is struck out for whatever reason. The authority can still go ahead and suspend or revoke your license if it is satisfied. And I think that is wrong. I think that it bypasses due process. It bypasses the principles of justice. And your only appeal mechanism is to go to the Private Security Appeal Board, which as a body, to my knowledge, doesn't even exist. It's a PO box somewhere, right? But you're out of work pending that. You have to prove yourself innocent, despite the fact that you've never been charged with an offence in that case, or you've been cleared of the offence in court. You then have to go and justify why you're fit and proper. I think that's wrong. I think it doesn't fit within the principles of law. I think there might be constitutional issues with it, and I'm amazed that nobody has raised these issues. I'm absolutely amazed that the representative bodies and the unions within the security industry haven't raised it. And I think if you are a member of a union, because this doesn't just apply to the enforcement sector, this applies to all sectors. So you could be working as a retail security guard or a doorman, and a complaint is made against you to the PSA, and the police decide not to proceed with that complaint because there isn't enough evidence, it isn't warranted. But the PSA could form an opinion on reasonable grounds that they decide that you are not to have a license anymore. And I think that's wrong. I don't think it should be in there. I think it's very, very dangerous precedent to set that the regulator gets to decide without any evidence just on what they deem reasonable grounds. And you know, who's to say that how reasonable those grounds have to be. The next section then is also a concern, subsection 3. It says they can revoke the license of an individual if they deem he is no longer or she is no longer a fit and proper person to provide a security service. If they deem. So you don't have to be convicted of anything. They just have to decide that you are no longer a fit and proper person. And once again, I think there's huge, huge legal concerns with that. You know, and ethical concerns with that a government body with no experience of the industry, none of whom have ever operated operationally in the industry, not one single person in the regulator has ever worked in the industry, to my knowledge. And they can decide that you're not fit and proper because somebody makes a complaint. And independent of the judicial system, they can make a decision based on that. I think that's wrong. I think that the security sectoral body, I don't know where our alleged sectoral body for employees is on this one. They haven't opened their mouth about it. And anyone that's in a union, I think, should be going directly to the union and saying, what is your thoughts on this one? That the regulator can all of a sudden decide on your livelihood. I think it's ridiculous. So another one down there then, it talks about, okay, well, they want to hold, and I can see why, that they want to hold organisations, and they say this on their website, they want to hold organisations liable for the actions of their employees. So where did I get that from? On the website, when they publicise this, and this is from the Department of Justice website, they say, the bill also makes a number of amendments, including allowing the PSA to refuse to renew a licence of a body corporate for the actions of its members. Now, I don't know in what country that could fit with due process and the legal system, but it certainly shouldn't in any democratic legal system with a decent set of common law principles. That a malicious action taken by an employee could result in the licence of a body corporate and the jobs of all the people who work for that body corporate being suspended or revoked. Again, not pending a conviction if the authority deems that it is reasonable to do so. People with no legal training and no experience of the industry deem it necessary to refuse or suspend or revoke your license. I think, again, it is daft. It is way stepping outside the bounds of where a regulator should sit. And again, I do not know where the ISIA or the employers themselves or any of them, whether they've been made aware of this, but I certainly think that security companies who are made aware of this should be going directly to the representatives and directly to the authority and saying, what's going on here, guys, because this can't be right for us. This is a massive risk. This should be going on the strategic risk register of every single security company in the country right now, you know, because it opens up a huge risk to them over the years that the malicious actions of one of their employees could result in their license being suspended or revoked, and the workplace. And it's just a reputational risk. Even if it's suspended for 3 or 4 days, and you have to go to your clients and say, actually, I have to put, you're going to have to get a different provider for 3 or 4 days because my license has been suspended because some guy in another part of the country has done something that he shouldn't have done without my knowledge. I think, again, it should be a huge concern for security providers. And then the final part of it that I have concerns about, again, relates to companies. And again, I don't know if companies were made aware of it or not, or have read about this, but if they deal with any director, shareholder, who any of the above applies to, is not a fit or proper person to hold a position as a director or shareholder, they can suspend or revoke the license. Again, I think that is way outside the remit, that they get to decide who is fit and proper to be a shareholder or director of your company. Based on, again, their reasonable grounds, no criminal conviction. Doesn't even have to be a charge. They just have to deem on their reasonable grounds that there is a concern here. I think it's a huge risk to all security companies and all directors of security companies. Now, that brings me back to the original purpose of the legislation, I suppose, which is the enforcement sector. And it comes back to, now, I don't have any clients in this sector, so I'm talking in a very, very general term, but if I did have any of my clients who are security providers come to me and say, I think there could be a bit of work in this area, I'm going to apply it. Well, one, they have to clear with themselves morally, ethically, whether that's a route, or even as a business model, that's a route that they want to go down. Some will. But secondly, I would very, very, very strongly advise them not to go anywhere near this in adding it as an additional sector to their license, because of the risks and the poor public perception that's around it. Because all it takes, according to these new amendments, is somebody to make a complaint against you. And the PSA, independent of the judicial system, even if you are legally cleared of that complaint, independently, the PSA can decide to suspend or revoke your license based on their reasonable grounds, independent of a conviction for that offence. Again, I think it's wrong. I think it's a massive risk. So you could have security officers working in corporate sites with corporate clients. You could have retail security guards. You could have door supervisors. You could have large event teams. And because they suspend the license, they don't just suspend one sector of the license. You could have one of your guys makes one mistake on one eviction or one repossession, and that can wipe out the jobs of all those people, independent, because the regulator can decide on their reasonable grounds, not due to any conviction or anything like that, or even pending conviction, that your company's license should be suspended. And then, I know if they were coming, their communications team would probably come, we wouldn't do that. We would take it very, very seriously. That's what they're saying right now. There is nothing in law that makes sure they have to do that. It says they get to decide the reasonable grounds, and then you get to appeal it afterwards while you're already out of business. So I think it's a massive risk. The final part of it then that I would say, and I don't necessarily think this is a bad thing, but it's something very much to be aware of. Apologies, that's the wrong one I meant to share. Down here, where am I gone? I'll open it up on this if I can. Stop the share. Basically, it says what they wish to do is they wish to be able to suspend or revoke the license of the company or any of the partners if the authority would not have granted or renewed the license if it had information subsequent to the date of its grant or renewal. So if they grant you a license, you go through all their alleged due diligence, you go through their background checks, you go through their screening, their employment screening that you have to do to be a director of a security company. And later, something comes to light, something in your past comes to light. Somebody from your past comes forward and makes a complaint and informs the PSA of something. Even if you weren't convicted of it, they can then go back previous, even if this happened before you had a license, they can go back and take that license away from you. Again, I think it's a massive overstep of judicial power. I personally don't think that this would be allowed to happen in other regulated countries. I certainly don't think it would happen in the United States market. I don't know what the companies in the UK have allowed this to happen, but it's certainly happening here. And it just has to be approved by the President. It's gone through the DAW, it's been approved by the DAW. I suppose it has to go to Shannon, and then the President has to go through due process. But at this point, if I was a security provider, I'd be having serious conversations with my legal advisors, and I'd be having serious conversations with my regulator and my representative bodies to see, can somebody get me something in writing that tells me what these reasonable grounds are going to be? And two, somebody get me some guarantees that this is not going to be used or abused outside the scope of it. So that's all I had to say for that. It's another week. I'm going to come back next week. I'll have a guest on next week, and I'm not going to say too much about it. But I think it's something that's very important. It's something that's coming down the line. I absolutely agree the enforcement sector should be regulated. I don't believe it should be regulated by the security. I think it should be regulated by an independent enforcement regulator. I don't think that repossessions and evictions are a security-related matter. But I would have grave concerns over the little amendments that have been put in there. I won't say by stealth, but they certainly haven't had as much fanfare as the other stuff. So until next week, this has been episode number 35. I shall talk to you all next week. Thank you for listening to the Security Operative podcast. We hope you enjoyed the show and got some value. If you'd like to follow more of our activity, you can find us on any of our social channels at Security Operative Consultancy Services. See you next time.